Any mention?
Yes,
To file a mention memo for listing a matter tomorrow.
Strange, you asking for listing. What's the matter about?
It's a
Your Lordship, this matter relates to the election of the Sardar of Nongiri. Now, this election is slated for 12th of next month.
What is already a matter pending?
Yes, that's what, my Lord. By virtue of the interim order passed by this court, now elections have been stalled. Because the petitioner here is not even...
Installed. No
Yes.
interim orders are there.
There is an interim order, my Lord, and this petitioner in the writ petition is not even a candidate. And another aspect is, my Lord, the poor, which is held by annually in Nongiri. That is also next.
It's a pending matter. Yes.
Your Lordship, I beg to mention item number 35 and 40, Your Lordship, on behalf of Mrs. N.G. Shilla. She's on sanctioned leave, Your Lordship. She's on sanctioned leave.
35 and?
40, Your Lordship.
No objection. Okay, after 1 week.
40. Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 39, Your Lordship. Let this matter be taken after 2 weeks.
30?
39.
You have objection? Okay, 2 weeks.
Please, Your Lordship. Your Lordship, I beg to mention item number 38
On behalf of?
of the respondent number 2, Your Lordship.
Who's respondent number 2?
I'm the landlord.
No objection.
This regarding it. It's regarding what this matter?
Regarding the run.
Landlord tenant matter?
Yes, Your Lordship.
Real petition, but. Okay, after 1 week. Yes.
No, Your Lordship, if with the permission after March 15, yes.
3 weeks, yes. Yes, seniors are there. Yes.
Please, Your Lordship, I pray for some accommodation for item number 6, Your Lordship, of supplementary list.
6 hearing.
Your Lordship. Senior counsel is before the division bench doing some part-heard matters, Your Lordship, for the last
This
3
matter
days.
is for closure.
Your Lordship.
Remains in this case, my lord. Is this for closure?
Your
You take
Lordship,
up the
I've
file
been in...
and you sit with it. By the time it comes up, you'll be well aware of the facts. It'll be called out. Okay? Yes.
Your Lordship, similar prayer for item number 27, Your Lordship.
Number?
27.
27. These are all connected matters.
No, Your Lordship, 27. It's not connected.
27, 28,
Connected, Your Lordship.
29. What to do?
1 week, Your Lordship.
We finish it off. 1 week.
Much obliged.
27 to...
27, 28, 29, Your Lordship.
You're there also? Okay. Yes.
Obliged, Lordship. Please, Your Lordship. Your Lordship, I like...
Till 31.
Your Lordship, we beg to mention item 34, Your Lordship. We are yet to seek instructions from the client, Your Lordship. 2 weeks' time, may
What do you
kindly...
mean, let's see instructions?
Your Lordship, we are not able to hold up a meeting with them because the entire executive committee is supposed to be sitting with us, Your Lordship.
The clarification has been given by the...
Yes, Your Lordship. So, we'd just like 2 weeks' time, Your Lordship.
Take 1 week's time.
Highly
Obtain
obliged.
final instructions. Yes.
Please, Your Lordship. Your Lordship, I beg to mention item number 33.
Where's the petitioner? This matter's ready. I mean, how many times has been taken? By who? By petitioner? By... It's regarding this dues.
Lordship, is this
What's the matter?
escrow account, Your Lordship?
Regarding?
The escrow account. Escrow account.
Escrow account.
Yes, Your Lordship.
Okay. You have no objection?
No, Your Lordship.
Okay, 1 week or 2 weeks?
1 week, Your Lordship.
1 week. Yes.
Lordship, item 32, Your Lordship. 32. Lordship, we pray that 2 weeks.
What remains in this case? Yeah, objection, Ms. Nokpur? 1 week, yes. We can't make this case just hang on like this, yes.
I'll oblige, Lordship.
Yes.
For item 41, Your Lordship.
Mr. Chanda.
No, Your Lordship. This is that witchcraft.
State respondents, my lord, they have filed a show cause to the misapplication.
What did
which
he
they
say?
have filed.
We filed an application praying for some police protection.
Yes, yes.
So we've deputed a quick response team of 6 officers.
They are there in the village, my lord. So if they continue to
No,
remain
but
there
the
for
thing is
some
that
time.
this is still happening because otherwise, well, we'll call those headmen here.
My lord, this
And
is...
once they come here, you won't know where they'll go after that.
My lord.
Lordship, we have filed an affidavit.
You're for the
perhaps
headman, correct?
For the headman.
Once they come here, if they continue these things,
Because
they
the-
might come here on your own accord. Where you go from here, you won't know.
Lordship,
This court is making it clear to the council. Where
Because-
they go from here, you
Lordship,
won't.
so far as the allegations of the petitioner, we have dealt with in our counter affidavit.
No, my lord.
Counter doesn't matter if you start
Because this
keeping on,
thing-
or keep on,
Yes.
harassing them.
We are not harassing them.
What
Your
you're putting after is different.
We are not
That's why we
harassing
want them to come only if they are being harassed, and if
We are not
if,
harassing them, Your Lordship.
then let them come. Then
The incidents, they continue to happen, and the arrangement made by the
Lordship,
police
Lordship, we are
department, my lord,
traditional
is just
institutions.
temporary.
So far as law and order is concerned, that is our most responsibility, Your Lordship.
it's not your responsibility. Now what's
Lordship, we
happening?
made-
What's been incited? I mean, it is an absurd case also. You know about the case, Mr. Sen?
So far as the
A
village
person
authorities
sees
are
a
concerned,
person in a dream that he's doing witchcraft, and you go and intimidate him.
Lordship, so far that allegation was, Lordship, we have counter in our affidavit.
He didn't see him in the dream.
Lordship, that
It was
that
madness.
isn't correct.
Anyway.
It can
1
come up-
week.
1 week, Lordship.
Yes. Otherwise, we'll close it
Obliged, Lordship.
or call them here.
In the meantime, my lord, let the police stay there in the village for some time.
They've been deputed.
No, that's up to them. Don't order there. Yes.
Obliged.
Obliged, my lord.
Supplementary list, item number 1.
Yes.
Please, Your Lordship. Your Lordship, this matter pertains to the non-action of the respondent authorities in settling the family pension in respect of the petitioner deceased husband, Your Lordship.
Who's the petitioner? The widow.
Yes, Your Lordship.
When did the person died in harness?
Your
when?
Lordship, yes, Your Lordship. He died in harness on 22nd 9 2020, Your Lordship, leaving behind the petitioner and her 2 minor children, Your
Okay,
Lordship.
take issue notice. You accept this on behalf of all the respondents. Yes, heard. Issue notice. What about this Directorate of Urban Affairs? You're appearing for all of them. This is from Garhills.
Yes, Your
You're
Lordship.
appearing for all of them. See the list of parties. You accepted notice on behalf of all the party, all the respondents. Yes. Okay, here's so-and-so. Issue notice, so-and-so accepted
Lordship.
on behalf of all the respondents for a notice called for. Just after 3 weeks for...
Your Lordship, I pray that, Your Lordship, in the meantime, Your Lordship, to release the debt cum retirement benefit, Your Lordship.
Let them come instructions first, whether entitled or not. Yes, after 3 weeks.
Item number 2.
You waited since 2020 till now. Wait for another 1 month.
May it please your Lordship. Lordship, this writ petition is the outcome of the speaking order dated 29/1/2024.
Outcome of?
Speaking order dated 29/1/2004, that is Annexure P.
Annexure?
Annexure P.
Page?
Page, Lordship, 76. Kindly come to
76?
page 76. Kindly come to page 81, which
One
is the
second.
operative part, Lordship.
Order dated?
Speaking order dated 29/1/2024. Operative part is at page 81, Lordship.
The type copy?
Paragraph 7. Now,
Yes.
now, therefore, in the light of the facts and circumstances enumerated in the preceding paragraphs, the competent authority, after detailed examination of the representation of the petitioner dated so-and-so, is of the considered opinion that the request of the petitioner to operate his SCR, APAR, awarded to him by his reporting officers purely on the basis of the performance during the respective assessment years lacks merits, therefore is hereby rejected, Lordship. Lordship, Lordship, my SCR, Lordship. Kindly.
No, what is, why here again before the court?
Lordship, here, Lordship, this speaking order was issued by the respondent number 2. That is the Director
basis of
General
which
of
order?
In persons with the order dated, Lordship, that is 5/12/2023. That is Annexure O, page 70, passed by the Honorable Guwahati High Court, Kohima bench, Lordship.
How come Kohima have come here?
Lordship, this is now the issue is different, Lordship. Separate issue, Lordship.
It is an order of the court of Guwahati High Court.
Guwahati High Court, Manipur
Speaking
bench.
order. Now you agree with the speaking order is given on the basis of order, and why are you here before this court?
Lordship, here, Lordship, I'm challenging only the speaking order, Lordship. They are.
Well, then why do you go to Kohima bench then?
Lordship, here the respondent number also is here, Lordship. Director
Doesn't
General.
matter. Why do you go to Kohima bench?
Lordship, this court also, Lordship, has
What do you mean this
jurisdiction.
court also?
Has jurisdiction to.
That's not that. You can't just pick and choose. Suppose you feel that you're not going to get any orders from Kohima bench.
Lordship, Kohima bench has directed the respondent to dispose my representation.
Exactly, dispose.
Then
now,
they
now
have
you're not,
they have
now,
disposed,
now
but
you're not happy. Now what is this at Annexure 20, at page Annexure A? This is Manipur also event.
Lordship, these are the chronological of the events, Lordship. Chronological events, Lordship.
No, Mr. Deb, first, what is this? 1920
Lordship,
Manipur.
This case is basically related
With
to the SCR, Lordship.
With regards to ACR, even in Manipur also, first case.
Lordship, Manipur, Lordship, that is a chronological events, Lordship. How do I got the
So now
adverse
after you finish
remarks, Lordship? That's why I have.
Manipur, then you go to Guwahati, Kohima. Next you come to Meghalaya High Court. Next Tripura I'll go.
No, Lordship, why I went to this Kohima and Imphal High Court, Lordship? Because, Lordship, I have established the chronological events, Lordship. Why I have received the adverse SCR?
Where do you receive who's your reporting officer?
That is, Lordship, respondent number 5 is reviewing officer.
Is he based in Shillong?
No, Your Lordship.
Then?
But
where is he stationed?
He's in Tripura. Respondent number 5 is mentioned Tripura.
Tripura, that means you have to go to Tripura High Court now.
But, Lordship, I'm agreed by the speaking order of the respondent number 2, Lordship.
How do you this, Mr. Deb? You have gone to Manipur to Nagaland to Meghalaya. Now,
Lordship, these are the chronological events, Lordship. These are the facts, Lordship, I have placed before this Honorable Court, Lordship.
Okay, I've not seen the facts, but is the cause of action the same from the time you went to Manipur High Court?
Lordship,
It comes to the same cause of action.
Lordship,
is the same cause of action or the one before this court now is a different cause of
Lordship, the
it's the
cause
same
of action is different, Lordship.
Please listen. It's the same cause of action, this WBC 494/2020.
Lordship, here, Lordship, my prayer was only to dispose my representation. They have disposed my representation.
Where, Manipur?
Yes, sir, Lordship.
Then what happened after?
Thereafter, Lordship, they have disposed my representation. Then they have passed this impugn speaking order, Lordship.
They disposed representation. Then why do you go to Nagaland to Guwahati High Court, Kohima?
Lordship, because, Lordship, this Honorable Court is also having jurisdiction, Lordship. Because the fresh cause of action, Lordship. This is a fresh cause of action, Lordship. This is a fresh cause of action.
He's not getting relief when he's bench hunting all over the Northeast.
No, Your Lordship, because this is a fresh cause of action, Lordship. That's why, Lordship,
this court has severe
I
reservations
approach to this Honorable
You go
Court,
back to, where's number 5? Agartala, Tripura.
Yes, sir.
Number 2, okay, fine, headquarters, Shillong. Number 3 is Kohima. Number 4, 20 sector, where's 99 EPOs, where? Dr. Mozika.
Number 3, number 4.
Number 3, 99 is Kohima. Mr. Deb, number 3 is Kohima, number 4 is Kohima, number 5 is Agartala, number 6 is Agartala. You can't hunt, you can't go bench
No,
hunting
Lordship,
like this.
number 5 is, he was during the time
None of
when
them,
he has...
none of
Lordship,
the concerned officers and Shillong.
Lordship.
The only one is that DGR is here.
Lordship,
You take a call, otherwise you'll dismiss it next date. Just after 1 week, you obtain instruction. Otherwise, your petitioner will pay cost. Yes.
Item number 3.
Just after 1 week, yes.
Okay.
You can't do this. Along cause of action travel all over the place. Just with some rifles posted all over. Or if you pass an order now, okay.
Lordship, I may be allowed to take instruction.
Just you will draw it and file it before Kohima or somewhere.
All right, Lordship.
Yes.
May it please your Lordship. My Lord, here the petitioner before my Lord is is a member of the Meghalaya Forest Service, my Lord. She's a lady officer, my Lord. Now, somewhere in the month of December last year, my Lord, I have filed a complaint before the respondent number 2, that is the Principal Secretary, Forest Department, my Lord, alleging that my superior officer, under whose supervisions I was working, my Lord, have been sexually harassing me in the workplace, my Lord. Now, because of which, my Lord, I even had to go for a mental depression, my Lord. Medical attentions were there. Doctor certificates are there. I'm suffering from a depressive action, mental depressive disease and all, my Lord. Now, subsequently, my Lord, not able to take up anymore, I have filed a complaint, my Lord. Now, this complaint was never acted, and it went 1.5 months.
Complaint before whom?
Complaint before the principal, from the principal conservator of forest, my Lord, who was my Lord.
All departments have to have internal complaints.
My Lord, exactly, my Lord. Now what happened is, my Lord, 1 month, 1.5 months, nothing happened. Now, in the meantime, they were forcing me to compromise, my Lord. They were forcing me to compromise. I said, I'll not compromise, because I had enough. I'll not compromise. Now, Vishaka's guidelines are very clear. I need to have a protection, my Lord. When a lady is filing a complaint of sexual harassment at a workplace, I need to have a protection. The law is very clear also now. In spite of that, they were asking me to compromise. I said, I'll not compromise.
When was the complaint filed?
19th December, my Lord.
Last year?
Last year, 19th December.
Okay.
Now, nothing happened.
Complaint.
Yes, my Lord. That was the first complaint. Now, what happened was on 1st of February this year, my Lord. There was two instances. Before the 1st of February, there were two instances in the month of January, late January. One very high-speeding car tried to bash me, tried to run over me, my Lord. Somehow, I was safe. This happened twice, my Lord. So, my Lord, after that, then I filed a complaint to the Superintendent of Police, bringing a record that because I suspect now, because of the complaint and also pressurizing me to compromise, I'm not doing. So therefore, somehow they're trying to scare me. They're trying to scare me, all this thing. Now, immediately on 1st, when I filed before the police officer, now, 1st of February, my Lord, when I filed before the SP, immediately on the 1st itself, the internal complaint committee writes a letter to me saying that you file your complaint. Since you disagree to compromise.
Okay.
Now Section 10 provides conciliation at the instance of the aggrieved lady. All this while I've been saying that I'm not interested. Now, just to cover up their lacunas, without any, they just to cover up. They've this thing. On 6th, I have also filed my complaint against the redressal committee, my Lord, the internal, the complaint committee also. On 6th, they have ordered or transferred me to another place, my Lord, which is a very secluded place. My Lord will see the forest colony, my Lord.
Now you've come against what here?
My Lord, now I have come again. Now two things are there, my Lord. I was asking, my Lord, to stay the transfer order for now.
Why?
Because, my Lord, I feel...
Transfer won't be safer for you if is the person you allege who's harassing you is in the same office with you where you're working.
My Lord,
now.
They can do two things happen.
No, just
yes.
Answer yes.
Yeah.
Now, would you
of course, my Lord.
Transferring out from here be in best interest for you?
It is, my Lord. It is, my Lord. But, my Lord. But you can transfer me to another safer places. But this one, I'm saying that this is not a safe place because it's very secluded.
Unsafe?
Because it's a very secluded place, my Lord. It's a very, my Lord, since forest area, it's a very deserted kind of. It's a forest colony, my Lord. I am from the office here in Lachumer. from Lachumer are being transferred to a place where it is more secluded, my lord. That is where my apprehension is that I'm scared of my life. Please do not transfer me. Transfer me anywhere else.
Has been filed with regard to the attempts on your life.
I'm sorry?
FIR has been filed.
Yes, FIR has been filed, my lord. FIR has been filed, my lord. Now, my lord, now on 27th, when I made this mentioned before, my lord, immediately on 27th evening, my lord, they passed another order transferring me to district council, my lord. Just to...
District council?
Yes, my lord, district council.
So first you transferred to another place in Forest Colony.
Forest Colony. Then when I say that, because I made a mention here, saying that my life is at risk.
Mention where?
Mentioned before this court, my lord, on the 27th.
You made a mention.
Mention memo, my lord, by way of mention memo.
Where is the transfer order?
My lord. My lord, the transfer order is page 28, my lord. Page 28.
The first transfer order.
First transfer order, my lord.
Yes.
In the interest of the public service, Srimati so-and-so Shulai, Deputy Conservator Forest so-and-so, is now holding, these are her, is, my lord, see the third last line,
yes, okay,
is transferred and
posted. The second order. Now this is dated 6 February.
Yes, my lord. The second order, my lord, we have, because this has already been filed, we have not brought on record, my lord.
Why?
Because this was passed very lately, my lord.
When, yesterday?
My lord, yes. Somewhere.
You bring it, you have a copy.
27th, my lord.
You have a copy?
My lord, I have in my soft copy.
First a copy first.
My lord.
Yes. We take it up after some time, you can take it tomorrow if you want.
My lord, my lord.
No. This is married tomorrow. Yes. On your own accord from the office, please try to obtain some instructions.
Some instructions as well.
Obliged, Lordship. Tomorrow, tomorrow, my lord. Oh, my lord, obliged.
Yes, any instructions?
But I'm still awaiting instructions.
So what to do then?
The matter can come on Monday.
My lord, may I please your lordship? Lordship, transfer order has come in this matter.
Movement order has come?
Yes, movement order has come. It is from 27 of this month.
Put it on record. Where is it? Who's your local council?
It's AP Kharsongkho.
Who is that? Where's the movement order?
Movement order, I have just received it today from my client.
Okay, let's on Monday. Let them come instructions. Yes.
Monday. May be given, otherwise he will be moved.
Monday you come with the movement order. You should have been here today and produced the movement order, yes. Yes.
Daily list, item number 1.
Deputy.
Yes, Chanda.
This is that matter regarding the review of the order dated. On the last occasion, the state were supposed to come with instructions.
Yes, instructions, my lord. My lord, as far as lump sum, as far as colleges getting lump sum grants are concerned, there are no specific rules, as I had mentioned last time. But what we do is we have to ensure that these grants are being used properly. And therefore, if there is a request for reconstitution and there are claims, counterclaims, or we hear about misappropriation of funds, then we obviously, as
only one thing with regard to reconstitution of governing bodies, what is the method you have developed? I mean, what is the method you use?
Normally we agree. Normally we don't refuse. But in this case, as my lord would say, see, there were the order that we filed last time, 10th October 2023, a third paragraph, and whereas as directed by Honorable High Court, I have re-examined the proposal for reconstitution of the governing body, and in view of the fact there are claims and counterclaims and also complaints on misuse of government grants and mismanagement, the proposals for approval of the governing body submitted by so-and-so
then we'll dispose of the review, Mr. Chanda. We'll modify or extend with regard to applicability of those rules and say that since it's not a deficit college, since it's a college receiving granted aid only, so they have the the thing that approval has to be received from the state respondents.
My lord.
And in this case, because there's some inquiry going on, an audit, they have not approved your governing body, and they're waiting. Director of Local Audit is requested to conduct audit, and meanwhile it's under the management of the Directorate of Higher Critical Education, the principal to assist. So what do you want to do?
Lord, if I will take instructions, my lord, then
no need for instructions, nothing, because the thing is that you agree with that. Now your governing body won't be is not being approved because of this order dated 10 October 2023.
My lord.
You know that?
Yes, my. I'm aware.
Yes.
Okay, my lord.
We'll dispose it of?
Oh, my lord.
Yes.
Also, my lord, this is a subsequent development. This may not come in the
No,
because this can't be a matter of review. This order can't be.
Yes, take down. This is a review application for review of the common judgment and order dated 28/9/2023, passed in WPC number 287 of 2023 and WPC number 326 of 2023, wherein this court had directed that with regard to the approval of any fresh governing body of the college, the respondent number 2 shall dispose of the same in accordance with law and to adhere to the Assam Aided College Management Rules 1976. Stop. The step next paragraph. Review petitioner has submitted that the fact that the Assam Aided College Management Rules is not applicable, 1976 is not applicable to the college of the writ petitioner, writ petitioner college, as much the same receiving of grants and aid only.
Lump sum grant.
Lump sum grant was not brought to the notice of the court, and as such, the same occasion, the order of which review sort of stop. Next paragraph, MSSI appearing for the respondent number 2 submits that the submission of the repetition is correct, in as much as with regard to colleges receiving lump sum grant, these rules not applicable. Stop. Whoever submits that in the normal course of business with regard to dealing with these colleges, the state respondents are the Director of Higher Technical Education. That is, respondent number 2 is the competent authority for granting of approvals for the constitution of the governing body. She further submits that with regard to the college, the approval has not been forthcoming in few anomalies which have been detected and which are being looked into. Stop. In the view of the matter, as not disputed with regard to the application of the rules. Where's the order? The order passed earlier on.
My lord, it's on page 105, my lord.
105. The observations in the order dated, that's the order in the review dated 28/9/2023, as far as
Para 8, Lordship.
Para 8 is concerned, shall not form part of the order any longer and shall stand reviewed and deleted therefrom. Stop. Accordingly, is directed that should we pass any further orders? Not necessary. Accordingly, the review petitioner stands allowed to the extent indicated above to dispose of. You take your chances with them only.
Item number 2.
May I please, Your Lordship?
Yes.
Conducting counsel is out of station. Let this matter must become up to 1 week, Lordship.
Your Lordship, here the petitioner has been seeking time and again, Your Lordship, on each and every date. In fact, the matter has already become infructuous, Your Lordship. The cancellation of work order against which they have approached this Honourable Court, it has already been completed, Your Lordship. The completion certificate has already been issued.
Let us see. Why is Mr. Pitisama hiding somewhere?
No, Lordship. He went for the hospital. His son is not well, Lordship.
Oh. This is regarding that the cancellation of work order.
Yes, Lordship.
Wrong name.
No, Your Lordship.
No, Lordship.
The work order, Your Lordship. Here,
Okay.
I've also got the third-party inspection agency report, Your Lordship, which says that
Let him. Let it come after 2 days or next week. Sorry. Okay, this matter next week. Let's
Your
pose it
blessed
up.
Item
Due
number-
to the unavailability of the counsel for the petitioner, this matter next week.
Item number 3.
As per the last order, I was required to facilitate a meeting between the petitioners for a settlement with the managing director of the corporation. Because he was a little preoccupied with the assembly session. We were trying to organize a meeting this week, but somehow it's not worked out. I had proposed Monday. MD is available on Monday.
Yes. Very difficult client Mr. Chakrathi has also. Yes, parties pray that the matter be listed on Monday. After
Perhaps next week sometime.
After 2 weeks, yes. To
Anyway,
facilitate the settlement.
Item number 4.
I filed my rejoinder.
Yes.
The short
Who's
issue.
appearing for the state?
Mr. Abraham.
What's the matter about?
But this is regarding a change of name of parents, adoptive parents, in the original scheduled tribe certificate. Now, he possesses a scheduled tribe certificate. All I wanted was for change of the name of
To
the
adopted
parents.
parents.
Yes, in terms of the order passed by the district judge. Now,
His original title is what?
Nongspung, my lord.
No, the one who's seeking.
Nongspung.
Okay.
Now, my lord,
This is he's a nephew actually.
nephew, he's an orphan, so the aunt has adopted him.
You want to reflect the name of.
So we just want to add a middle name, my lord. Now what they have done is they are asking for the NOC from the clan and a tribe certificate under the Lineage Act, my lord, District Council. Now even under that act also, it provides, my lord, that a person whose both parents were original parents were, the word used is were. Scheduled tribe, my lord, he is a Khasi tribe. He is a tribe, my lord. So there's no compulsory registration, my lord. Now the objection raised in the counter is that we have not applied it through online. Now upon receiving that, we have applied online, and now we are back to square one, my lord, where they are again asking for the NOC and the tribe certificate.
When's Abraham?
My lord, he's not available today.
Actually, we won't post it for hearing. We'll fix it up for orders, and it can be disposed of.
Yes,
It's a small matter.
Yes, my lord.
Because if there's no the child is a tribal.
It's a tribal, my lord.
Only that he's an orphan.
Yes, my
taken over his aunt.
Yes, my lord. Now I don't require to take the NOC of the clan or the tribe certificate.
1 week.
My lord.
This rejoinder has been filed by the petitioner. It's a matter after 1 week for orders, for further orders.
Obligement.
Item number 5.
And in this, we filed our affidavit, and we've raised a preliminary objection with regard to the maintainability of this application. So, the grievance of the petitioner, my lords, if I can just summarize it, it's with regard to non-payment of compensation and with regard to payment of compensation to the wrong parties. So there are 4 stretches. If lordships will kindly have my affidavit.
Did the affidavit filed today?
On the 29th, today. Is it on record?
Yes. Yes.
Kindly have page 3. So the transmission towers were erected in 4 stretches.
Excuse me, here.
So in subpara B, lordships will find there are 4 tower locations that are indicated.
Yeah.
In respect to the first 2 tower locations, compensation has already been received by the respondent number 13, rightly or wrongly.
Who's 13?
My learned friend is appearing for the respondent number 13.
Number 13. Ex-headman.
Who claimed to be the headman. In that capacity, it received the amount.
Khasandi, yes.
So rightly, wrongly, that has been received. In respect of the second two tower locations, they are aggrieved with the... Malods?
2 and 3.
3 and 4.
Okay, they have received
in
1 and 2.
respect of 1 and 2, it has been received by...
taken by the ex-headman.
Lordship. Respondent number 13.
Okay.
And so there are grievances with regard to that as well. That he is not entitled to receive it.
You are the Lingdo Moplang.
Yes, my lord.
Lordship.
This Craig is a Lingdo Moplang.
Lordship.
Okay. Yes.
And
so
in
1 and
respect
2
of
is been taken by
respondent number 13.
Okay, R30. Don't dispute that, Mr. Lingdo. You've taken.
So there are payment receipts as well.
There are receipts.
Okay. Okay. Then 3 and 4.
3 and 4, my lords, there are grievances with regard to the amount that has been decided. That they have fixed 1,000 rupees as a flat rate per square foot towards compensation. They are aggrieved with the sufficiency of that. Now both these issues,
now,
both
that
these
money
grievances, that hasn't been released as yet.
Okay. 3 and 4 not released.
So, my lord, so these are the two grievances that they have. In our respectful submission, both can be dealt with under the Telegraph Act. There's an alternative statutory remedy under Section 16.
Why is towers come to Telegraph Act? These are power towers.
I was also not sure about it. So they say all disputes will be governed by
Electricity Act.
So the license are issued under the Telegraph Act. That's the same stand that has been taken by Power Grid as well.
The powers we have under the the Telegraph Act.
Okay.
We've also mentioned in our counter affidavit.
So kindly see Section 16, subsection 3. So if any dispute arises concerning the sufficiency of compensation paid under Section 10, Clause D, it shall on application for that purpose be either of the disputing parties to the district judge within whose jurisdiction the property is situated.
Now in this writ petition, what are they seeking?
Two issues. One, that the amount that has been paid to the respondent number 13, that should be retrieved and paid to them.
Yes.
And as far as the amount that has not been released, for the other two stretches, the compensation should be enhanced. So at page 29.
This is a different kind of dispute because they say the land belongs to the Raj, right?
Lordship.
Of the Rihima. And number 13 says belongs to the village.
Yes, Your Lordship.
And so it's outside their jurisdiction. That is it's a title dispute.
And Your Lordship, with respect to the relief, as prayed also, there's nothing, no relief was sought against me. But as per the relief they have sought for Your Lordship, that for enhancement of the compensation.
No, they're making a blanket prayer that whatever these 4 sectors, whatever, all compensation should be paid to the right,
to the Hima.
Because of the right to Moplang, that's all. What should we do then?
My lord, in regard to the compensation, was my learned friend has submitted in regard to 2, 3 and 4. We in our writ petition also there is an application, my lord. We have a representation we have given to the authority, deputy commissioner.
No, not that. What we see, Mr. Nath, now is in 2 parts now your writ petition. One is that the money is already gone. Then they have other reliefs
Yes,
for
my
that.
lord.
He's already taken that money. It is around a title dispute. Not title dispute is a who
dispute in
belongs
regard
to
to
the
the
village or to is the Raj
Yes.
of Moplang. That we can't settle in the writ petition.
So that also is available under Section 16(4), the remedy.
Even whether it's right Moplang
In
or
case
village.
if it's paid to a wrong person. If that is a grievance.
Mongap village, correct?
Yes, Your Lordship.
And you've been sacked also.
Yes, Your Lordship.
They had filed a writ petition as well.
That's been disposed of.
Disposed of. Yes.
What's the order?
My lord, I don't have the file, my lord. I'll pray some time, my lord, to.
No, you go through the affidavit filed by the state.
Affidavit I've seen, my lord.
Filed today
It's
by
with me.
the respondent numbers 2, 9, and 10.
Accordingly, we'll give the short rejoinder, my lord, on that.
2, 9, and 10. Stop, Miss. Next paragraph, Ms. SN has submitted that alternate remedy exists for the prayers have been made by the writ petitioner. However, this is matter up to 2 weeks to enable
to give the rejoinder.
To file the rejoinder, if any. Yes. We'll take after that. You bring the order next date.
Do you have a copy?
You have a copy. What does it say? You were the petitioner there.
Yes, yes.
Oh, is the council looking into this?
Yes, Your Lordship.
But it's against your removal.
Yes.
Then it doesn't matter.
Different issue. There's different issue.
Yes, it's different. Yes. Just after 2 weeks, yes.
Ali Blash.
Ali Blash.
Can you give me a copy?
Item number 6.
Lordship, can you peruse the last order dated 31st of January, my lord?
Oh, sorry.
Yes.
Very small issue. I said the other day also, my lord. Without using the word blacklisting, if you debar a particular contractor.
Know what happened? You blacklisted. You blacklisted Mr. Singh. You blacklisted Mr. Nath.
Yes.
No, my lord. We have acted as per our clauses of the NIT which he has signed. My lord, we have given a number of letters to him to kindly furnish the security.
But you blacklisted him.
No, we have just debarred from. There is a difference between a blacklisting and, my lord, debarment, which I have stated in my affidavit in opposition, my lord. Kindly peruse, my lord.
No, just tell the court first. You debarred him for how many years?
For 2 years, my lord. As per the clause.
So his explanation,
yes, my lord. 7-4.
His explanation was not satisfactory. His explanation was not satisfactory. That's why you debarred him.
Because we have given what happened, my lord. he has bidded in the PDS system, my lord, for transportation of food grains, my lord. And then thereafter bidding, he requested that he want to withdraw his candidature. But as per this clause 8.1, that after the contractor bid, it cannot be allowed, because now the system is in the e-portal, my lord, where his manual intervention is not there, my lord. Thereafter, when he was found L1 bidder, we have asked him.
In your e-portal, suppose a contractor finds that he wants to withdraw from the bid.
No, it cannot be, my lord. It cannot be, my lord, because in e-procurement side.
Let's see your affidavit.
My lord.
Where do you say that? Mr. Nath, just 1 second. Let's see what is that. Where's your affidavit?
My lord, last page, my lord.
No, because only thing is to consider is whether.
My lord, in termination letter there is a true facet.
Let's see your affidavit. Where do you say?
Yes, my lord, at page 7, my lord.
You're for 2 to 6.
2 to 6, my lord. FCI Corporation, my lord.
Page?
Page 7 of my affidavit in opposition, my lord.
Okay.
In the middle part, my lord, I further say that the petitioner was never given any verbal assurance as alleged by the petitioner that her technical bid will be disqualified. He has taken many plea, my lord. It may be pertinent to state herein that the petitioner, being an experienced contractor of FCI, was well aware of the clause 8L of the tender document, which clearly stipulates that it should be clearly understood by the tenderer that no opportunity shall be given to them to alter, modify, or withdraw any offer any stage after submission of this tender. The said clause was also agreed by the bidder while submitting the tender, my lord. My lord, that 8L, clause 8L will be, your lordship will find at annexure H, my lord, at page 26, my lord.
8L.
Annexure H, page 26, my lord. The annexure H page, it starts from page 25. L is the relevant part, is at page 26, my lord.
It should be clear on the tenderer, no should be given to them to alter, modify.
It should be clearly understood by the tenderer that no opportunity shall be given to them to.
Okay, fine. So what's the consequences of this?
Then thereafter, he was awarded the contract, letter of acceptance was issued, and thereafter he was asked to furnish the security deposit and the bank guarantee, my lord. Then he refused to do, and we have given numbers of letters that which we have annexed in our.
Okay, fine. So this tender, he signed the tender.
Then we have issued the termination letter, my lord. The termination letter has got two facets, my lord. That termination letter has been annexed, my lord, in my affidavit in opposition also.
Page 121 of the writ petition.
So let us see 121. Paragraph 121, my lord, clause, para 4. Whereas this office, while emails dated 2010-2023, 3/11/2023, 7/11/2023, reminded the successful tenderer to deposit the security deposit bank guarantee along with
clause number?
My lord, at 4.
4. Okay.
That after he was successfully, whereas the office by referred emails dated 20/10/2023, 3/11/2023, 7/11/2023, 10/11/2023, and 13/11/2023 reminded the successful tenderer to deposit the requisite security deposit bank guarantee along with the original signed tender document, also intimating that failing the same, action under clause 7, 4 and 9F will be initiated besides invocation of risk and cost, my lord. Whereas this clause 7A, 7F and 9F stipulates, which has been quoted here in below, my lord, which says that it can be after his failure to give, we will terminate and we will issue another tender, and then
7, in the event there is failure after communication of acceptance, tender to furnish
page 20 to 22 of that. The contractor will also be debarred from participating in any future tenders of the corporation for a period of 2 years. After the completion of prescribed period of 2 years, the party may be allowed to participate in future tenders of FCI provided all the recoveries dues have been affected by the corporation and there is no dispute pending with the contractor party. Whereas it is well-known fact that the instant tender inquiry handling and transport of food grains was invited for catering to PDS requirement area. Now, my lord, paragraph 8. Further, corporation shall proceed for placement of another contract at the risk and cost of the AS transportation. Any losses or damages arising out of the same and incurred by the corporation in handling transportation of the so-and-so will be recovered from the tender contractor with prejudice to any other rights and remedies to the corporation under clause 10 and then under clause 11 summary termination and clause 12 set off etc. of the tender document of the law of the land.
Yes. Right. So you say that whatever actions you've taken is
as per the clause, my lord. And that clause has not been challenged in this petition. The clause L and then clause L says that it cannot be withdrawn.
Only withdrawn.
Clause 7, 4 and 9F.
Tender conditions.
Yes, I'm 7, 4 and 9F, my lord, will find
in the tender document.
In the tender document, my lord.
Which page is that?
Yes, my lord. My lord, at page 35
of the affidavit
of the writ petition, my lord.
35. Page 35.
Page 35, my lord.
Yes.
In the event of the
One
clause
second.
4, my lord.
This is the.
This is clause 4 of 7.
This is
security
the tender
deposit.
document.
My lord.
One second. Okay. Clause
7.4, my lord. Subclause 4.
Yes, okay.
Page 35.
Right.
May I read it, my lord? In the event of the tender's failure, after the communication of acceptance of the tender by the corporation to furnish the requisite security deposit under clause 7.1a by the due date or requisite security deposit in the form of bank guarantee under 7.1b and 7.1c, including extension period applicable to the submission of BG only, his contract shall be summarily terminated beside forfeiture of the earnest money, and the corporation shall proceed for appointment of another contractor. Any losses or damages arising out of or incurred by the corporation by such conduct of the contractor will be recovered from the contractor without prejudice to any other rights and remedies of the corporation under the contract and law. The contractor will also be debarred from participating in any future tender for corporation for a period of 2 years. After the completion of the prescribed period of 2 years, the party may be allowed to participate in future tenders of FCI provided all the recoveries dues have been affected by the corporation and there is no dispute pending with the contractor.
Yes.
Then, my lord, clause 11, 9F. Clause Roman 9F, my lord. Your lordship will. 47, my lord.
In the event, yes. Okay. Okay. Yes, Mr. Nath, you signed this contract.
I'm
And
coming
if
to
the
this, my
tender,
lord.
general conditions, of the agreement.
My lord, another one thing that my learned friend has said that he has been blacklisted. In this regard, my submission is that he has not been blacklisted. He has been debarred. Debarred, my lord, from debarring him from applying in FCI only.
He's not entitled to show cause. If you're debarring, even if the general terms of agreement, it can't override natural justice. I mean, if you're going to debar him for 2 years, okay, fine.
We have not
happened
specifically.
to
We have
the
not
contract now,
specifically.
well and good. He's bound by that. He sought to withdraw. You're not allowing him. You're going to impose risk and cost on him. That's a different matter. But whether,
my lord, we have not specifically used the word debarment. We have, while writing several letters, we have quoted that action will be taken as per the clause 7(4) and 9, clause 9, my lord. The petitioner contractor was well aware of this fact, my lord. And against that 4 or 5 or 6 reminder, he has given only one letter apologizing that we are very sorry to give the unrealistic this thing. And the second bidder was only, there is a difference of a few thousands only. So that was not unrealistic, my lord. Because at their own will, they want to withdraw, my lord.
He's finished.
Once he finished, yes.
Let him finish.
So at their own will, they want to, my lord, back out, my lord. And what happened, my lord, thereafter we have to issue, manpower is involved, time is involved, money is involved. Again, we have issued another tender, my lord. And then we lost, meanwhile to continue the PDS, we have to appoint on ad hoc basis, my lord. So the prices got high, my lord. And the subsequent contractors come to know about the rate also, my lord. So and the second contract, my lord, the rate gets high. That's why it is risk and cost when it is terminated, my lord. So I think my learned friend is only agree with the debarment, not at risk and cost. So regarding the debarment, my lord, my humble submission is that, my lord, several reminder letters were there quoting the clause, my lord. And against several reminders, he has given only one reply and very apologetic.
Where's the reply? Page?
My lord.
119 page. 119 page, my lord. My email to the general manager, FCI. Then 1120.
119.
Page 119.
Now, what is MSME?
MSME is the, my lord, it's a under which the contractor gets registered so that they are waived to give their EMD, earnest money deposit. So they also get scot-free, my lord. When they at their own will, they will withdraw. And we cannot revoke their EMD also, my lord. So that's the advantage they get. The petitioner is the MSME contractor, my lord. Registered under MSME Act.
What is the full nomenclature of MSME?
It's
Medium,
a micro, small, medium enterprises, my lord, Act, 2006, my lord. So they are misusing this MSME Act also, my lord.
Yes, Mr. Nath.
Make my submissions very clear, one thing, my lord. Lordship has seen the MP in order of termination, my lord.
Yes.
My submission will be treated of the legal submissions, my lord. They've used the word in paragraph 7. Just have a look once again, my lord. Page 122. Paragraph 7, last 3 lines. Instant contract is hereby summarily terminated with immediate effect. Besides debarment of transportation, Hasna Burbuya from participating. 122 page number. Paragraph 7.
Yes.
This is debarring, my lord. Yes. And that cost paragraph is these two, my lord.
Yes.
This is a case where, my lord, lordship can say, my lord, I kill somebody with 2 gunshots, my lord. I kill him and I say, I don't commit murder. It is like that. They debar me, my lord, here, and kindly have a look at this judgment of this. This will make very clear, my lord. This is exact on this point.
Okay, one thing, Mr. Singh. What's the difference between blacklisting and debarment?
There is
blacklisting can be for until you...
Blacklisting will be, it will be, they are put under a list that, so that all the government organization or
the other contracts...
Yes, my lord. They will be blacklisted from all the organizations.
One of the requirements that you are not being debarred by any other entity also.
No, not.
It's not here in your...
No, only debarment in my organization.
In your tender notice, does it say that if you're debarred by other...
No, my lord. But that way I have read, my lord. 7-4.
If he's debarred here by FCI, he can
only
go...
FCI.
He can go
for
and
2 years
tender anywhere else.
Yes, my lord.
Obviously, he cannot do for others, my lord. He can do it within his compound only, not beyond his compound.
Because of your conduct, my lord.
My lord, kindly just have a look at the judgment of this honourable court, my lord. My lord, 1 minute. Paragraph 16, last but one page, my lord. Last but one. Para 16.
Para?
16. Bottom. And also, my lord, first lordship may come to page paragraph 15, my lord, page number 10, just previous page number 10, right side, my lord, bottom.
Yes.
Lordship has seen para 15?
Yes.
It follows from the above judgment in Eurasian Equipment, 1975 1 SCC, said that decision of the state or its instrumentalities not to deal with certain persons or class of persons on account of undesirability of entering into the contractual relationship with such person is called blacklisting, my lord. Lordship has seen, this is the answer. Since 1975 till today, this is being followed, my lord. You don't use the word blacklisting and you debar me for 2 years. Is not it a blacklisting? That means blacklisting for 2 years. That's the meaning. And the Honorable Apex Court and this Honorable Court has ever relied on that, my lord, and passed the judgment. Now the next question will come, my lord. Without using the word blacklisting, now they are saying, no, we have not blacklisted. But it's very clear from the judgments also. Debarring for 2 years is a blacklisting. Now, if it is a blacklisting, then what are the procedures to be followed? This is the next case, my lord. These laws are known to your lordships, my lord, actually. I'm just repeating that, so nothing else. First, my lord, para 25, my lord, last page, kindly have a look. Para 25. He's talking about clauses, my lord. 10, page 35 and post 37 of the petition, my lord. The answer is here, my lord. The mere existence of a clause in the bid document which mentions blacklisting as a bar against eligibility cannot satisfy the mandatory requirement of a clear mention of the proposed action in the show cause notice. That's what, my lord. The corporation's notice is completely silent about blacklisting, and as such, it could have led the appellant to inform that such action could be taken by the corporation in pursuance to this notice. Had the corporation expressed its mind in the show cause notice to blacklist, the appellant could have filed a suitable reply for the same. Therefore, we are of the opinion that the show cause notice dated such and such does not fulfill the requirements of the body show cause notice for blacklisting. In our view, the order of blacklisting the appellant clearly traverses beyond the bounds of the show cause notice, which is impermissible in law. As a result, the consequent blacklisting order cannot be sustained. My lord, kindly just look at the name of the parties. First page, my lord. Please, my lord.
FCI.
FCI. Now, in spite of the judgments, my lord, repeatedly the Honorable Apex Court, the lordship is also saying again and again, it's a mandatory requirement show cause notice. In spite of that, the same FCI, my lord, same mistake they are again and again they're committing. What's the harm, my lord, using show cause notice? Repeatedly, my lord, in this entire judgment is on the basis of show cause notice, my lord. This is why I said, my lord, there's nothing new, my lord. It's known to your lordships, my lord. Yeah. Lordship has seen, my lord, Ajmal Kasab. Lordship has seen, my lord, whole Ajmal Kasab, the Pakistani. Whole world has seen in the TV. He was shooting one after another in Bombay, my lord. Was he hanged, my lord? Or there was a trial? There was a trial. Even whole world has seen that scene, my lord. There was a trial. Here, Apex Court and your lordship repeatedly saying, issue show cause notice, issue 8. Mere existence of the clauses doesn't have anything to do, my lord. You have to follow the rules of law. That's what, my lord. And my lord, kindly see the findings in both the cases. Set as and quashed. No other observation. You do this because lordship is not their guidance, my lord, or their, my lord, advocate or anything. Yes. It is there who shall to guide, my lord. How many times the lordship will say, do this, do this, do this.
In your case, that whatever debarment amounts of blacklisting without following principle narrative justice.
That's what, my lord. Very big, first day I said, my lord, it's a case of 1 minute. Obliged, my lord.
Well, just two reminder letter, my lord. At page 20 of my miss case, my lord, for vacating the stay order, my lord. Page 20, my lord. We have taken the plea in the affidavit in opposition only also, but we have annexed in our stay vacating petition. Page 20, my lord, annexure E. That reminder number 2, my lord. Just 2 line I will read it.
Page 20.
Annexure E.
Yes.
And then above is reminder 3. Just I will read only 2 lines. It is hereby informed that your 15 working days are only up to 14/11/2023. Failing to deposit the SD amounting to rupees such and such as per clause 7 and 9 by 14/11/2023 will invite action in terms of clause 7, 4 and 9F, invocation of risk and cost, etc. as per the
So you think this amounts to show cause against the department? That's your submission.
We have quoted that too.
That we have quoted this thing that, you know, that there's not nowhere to say that, you know. Anyway, will you pass order in court or will...
Lordship, just have a look at one of these paragraphs here, my lord, paragraph 2, Supreme Court. My lord, issuance of LOI. Even somebody issues an LOI, my lord, and subsequent steps are not followed, my lord, it is not a concluding contract, my lord. Limited lordship is held, my lord. It's not binding, my lord. There are 22 and 23. Page 177. That's all, my lord.
Yes.
Well, this matter can be disposed of, my lord. My lord,
What's the matter about?
My lord, this is a matter, my lord, the petitioners, pursuant to an earlier advertisement, applied for the post, and they stood at number 1 and number 2 in the select list, my lord. But because of deemed abolition of post, we could not proceed with the appointment. Subsequently, a fresh advertisement, post was sanctioned, my lord. Fresh advertisement was issued. Again, they applied, and they are number 1 and 2. And we have offered them appointment. They have accepted the appointment, my lord. Only the appointment letter has to be issued.
You accepted the appointment?
So it's a provisional appointment offer. We have accepted, formalities have been completed, but the final joining letter has not been issued. So on the statement of the statement of learned senior, that can be close to that.
Yes.
Both of them, my lord. Number 1 and 2, both of them. The other one is...
There are 2 petitioners?
The 2 petitioners.
Both petitioners.
Frandis and Onicha syndrome.
Take down. The petitioners are before this court praying for directions to the respondents for revival of 2 vacant posts of reader therapy technician, which were advertised on 3/12/2022. 21. And for further direction to issue appointment to petitioners based on the selection results wherein the petitioners had come out successful, had been successful, sorry. Stop. The grievance as portrayed is that the post re-advertised.
Fresh post was sanctioned, my lord, and those were re-advertised.
Yes, it has been submitted, by Mr. Philamnambri, that fresh post, that fresh advertisement was, what were you saying?
New post was sanctioned and fresh advertisement.
That on new post being sanctioned, a fresh advertisement was advertised, wherein the petitioners participated in and also emerged successful. So, next paragraph. Dr. N. Musical DCI submits that the matter can be closed at this stage inasmuch as provisional offer appointment dated 12 February 2024 has been made in respect of both the petitioners. He submits that the formal appointment orders will be issued shortly. So, now, in view of this development, nothing remains for consideration and the petition stands closed. Communications, next paragraph, communications that have been produced by the DSI are taken on board. Communications of the letters of provisional appointment produced by the learned DSI, copies whereof are taken on board and be part of the record. Yes.
Well, appointment and their acceptance also we have placed.
Appointment acceptance taken on board and be part of the record. Matters stand disposal.
Item number 8.
Please, Your Lordship. Your Lordship, in this matter, we have not received any instructions. I'm praying for some time, Your Lordship.
Doesn't matter about.
Your Lordship, this is a land-related matters, Your Lordship.
It's a?
Land-related matters.
Compensation?
No, Your Lordship. In this matter, Your Lordship, I was deprived from registering my right. I was deprived from registering the landed property.
Land documents, Your Lordship.
Deprived by whom registering?
By
You are appearing for whom, Mr. Khalinda?
I'm appearing for respondent number 5.
Number 5. 6 is whom? Have you filed affidavits? You won't file? You'll file also? Respondents 1 to 4 represented by Ms. Ailingma, 5 by Mr. Khalindo, and 6 by the company for allowed for a 2 weeks time to file
3 weeks,
affidavit.
Your Lordship. 3 weeks, Your Lordship.
3 weeks, okay.
Obliged, Lordship.
9.
Yes, affidavit.
Lordship.
Not filed.
But I'm praying for 2 more weeks.
2 for the weeks as paid allowed for affidavit, yes, by the respondents.
10.
May it please, my lord. I'm appearing on behalf of the opposite party.
Your objection to the delay? You are objecting to the condemnation delay?
Yes, my lord, I will file the objection, but my lord, I would like to pray, give me 6 weeks time.
No.
My lord, the main file, the main probate file, including the petition for condemnation of delay, has been completely destroyed by fire.
Okay. Yes, also the appearance we have sole respondent.
Yes.
So no further notice is called for. Stop. It has been submitted that as the records of the respondents have been destroyed in the fire, he prays without time to reconstruct the same and to file the objection to the condemnation. This is matter after 6 weeks.
Much obliged.
Why do you keep the records inside the bar station?
Yeah.
Why do you keep the records in the bar association building?
My lord, we used to prepare cases, everything.
You don't take them home?
There are some that we prepare from home. There are some files that we used to keep in the bar. We laptop and all, everything completely destroyed.
Okay.
11.
Lord, counter affidavit has been filed in this matter. On the basis of newspaper report, they said that we are relocating the vendors, my lord. And your lordship may have a look at my counter affidavit, my lord. The process is, if your lordship will kindly see, the process which is at page 2
of the affidavit.
Of the affidavit, my lord. The answering paragraph 4, my lord. Answering respondent states that Government of Meghalaya wide notification dated 25th October 2023 has framed the scheme for street vendors called Meghalaya Street Vendor Livelihood Scheme 2023. That scheme has been framed to provide and promote a supportive environment for street vendors to carry out in accordance with the Act and rules. The answering respondents, paragraph 5, my lord, under the above mentioned scheme, the town vending committee, with the support from the local authorities, is required to conduct comprehensive survey on all existing vendors and vending zone. That as such, all surveys of street vendor has to be conducted in accordance with section 3 and 10 of Meghalaya Street Vendor scheme to 23, my lord, and then it is the scheme is quoted, my lord, after quoting paragraph 6, my lord, that with respect to Greater Limukra area, a survey under section 3 and to section 3 to section 10 of Meghalaya scheme was conducted by town vending committee. Pursuant to survey being conducted by meeting dated so and so, the chairman of called for a meeting of town vending committee on 6 February 2024. On 6 February 2024, meeting was held in the office of Chamber Secretary Muda. The first agenda discussed in the meeting relates to scrutiny of surveyed vendor, whereby it was decided that issue of claim and objection is to be furnished by all the vendors as proof. Furthermore, it was discussed that a list of street vendors will be published on the website of department and put on the office notice board on town vending committee, and applicants who were denied registration will be given opportunity to appeal through concerned town vending committee.
So one thing, who has taken the action according
So right now nothing, and paragraph 8
according to them, they say that steps already been taken to relocate.
No, paragraph 8, my lord, we have said paragraph 8, page 7, that on the date only survey has been conducted by town vending committee and no action have been taken in relocating, shifting the hawkers and street vendor of greater area to Lady Veronica Lane. Further, no order notification has been passed by the state government directing respondent to initiate process of relocation, and their apprehension, my lord, is
my senior Mr. Paul is appearing in this matter, Lordship. So I am praying, my lord, he is today, my lord, due to some difficulty, he could not be here, my lord. I am praying if this matter can be taken up on next week, my lord.
No, see, Mr. Chanda, that's the thing, because it's on apprehension. According to you, what do you say that they are being relocated immediately? That is the only thing. What was your prayer and petition?
For not relocating, my lord. For not relocating.
not permitted.
Yes.
You don't, like,
Withdraw, recall,
21 Lordship.
otherwise forbear giving effect to relocation shifting. What we are saying is, my lord, we have carried out survey and their apprehension was based on, my lord, page 32, the newspaper report.
Injunction, basically.
Injunction. And my lord, only survey and the whole apprehension, entire apprehension is based on the newspaper report at page 32 and 33.
Lord, I'm praying if this matter can come up next week, my lord.
So then everything, whatever we have
take
said.
instructions and we'll get back, my lord.
Okay, after it's been filed by the state respondents indicating the fact that there has been no orders for shifting of the vendors of Limukra to, what is that place?
Veronica Lane.
To Veronica Lane, and that no relocation can be done without adhering to the.
So first, my lord,
without a proper survey.
First survey we are carrying out survey, my lord.
Yes,
Then
thereafter
thereafter
survey and findings thereon.
Yes.
Yes, Mr. S. Chanda, please will have to obtain instructions.
Next week.
Just after 1 week, yes.
Item 12.
See, in this case, I have filed the caveat before the motion was moved, Lordship, but inadvertently the caveat was not listed and
So now you enter formal appearance.
Yes, Lordship.
No interim orders were passed.
Yes, Lordship.
So, Mr. S. Sheikh is present.
On behalf of private, Lordship.
That's for the number 4.
You know, caveat you can file any stage, any.
Yes, Lordship.
The caveat is not here.
On the motion there, it was not listed. So I am entering my appearance, Lordship.
Mr. S. Sheikh has entered appearance today on behalf of response number
4. Not 4.
only 4. As such, the notice is complete. How much time to file affidavit?
2 weeks, Lordship.
You are appearing for whom? CHDC. Yes, MS N. Raji prays for further 2 weeks time for affidavit. Similar, praise be allowed, 2 weeks time for affidavit. Praise allowed. Similarly, N. Raji has made a prayer for further time. This is a matter of 2 weeks for affidavits.
13.
Will you dispose of matters today?
My lord, here.
How long will report consideration? Are you waiting for it to germinate or something?
my claim is not admitted. My case is slightly different from others, Lordship. Here in this case, 10% has already been released, Lordship. The 90% is yet to be. They have not disputed my claim, Lordship. And it is matter of 2019, Lordship, now.
18, 19, 20
Yes,
is
Lordship.
matters.
And the land was acquired in 2006 or 7, Lordship.
What to do with these matters?
Lordship give a direction to conclude whatever consideration they have within a period of 2 or 3 weeks positively.
And close all the matters?
Close all the matters thereafter. Because we filed our affidavit in any case, because the entire liability lies with the union right now.
Where's Dr. Mozika?
And the matter is lingering for quite long time.
Honestly,
Yes, Lordship.
5-6 years. Yes, Mr. Paske.
Yes, Your Lordship.
Yes.
Lordship, the MHA has to file their report because we have completed our part.
No, they're submitting that these matters should be closed and directions be issued finally.
Your Lordship may issue direction that within a short span of time, let them be given 2 weeks or 3 weeks, as my learned friend has already spoken, that the status report be given, or else with some strict adherence to the order, so that they don't seek further time.
Let's have after some time, let Mr. Dr. Mozika come.
Supplementary list, hearing, item 5.
Yes.
Where's Mr. Qureshi?
It's around your.
Around? I don't see him.
Submission should be given from the government side.
We've already given a submission yesterday, Your Lordship, that there are no rules.
Day
We are
before
following
yesterday,
the
day
municipal
before yesterday.
rules, Your Lordship.
Authorities, Mr. Qureshi?
Authority. I didn't find any authority except.
No, because see, the thing is that to legalize your whatever your entire service as a senior grade driver.
Because as per the impugned order also, they are saying this, no rule is quoted, under which law I am debarred.
There's no rule quoted, fine. Where you show some authority when such a thing has happened.
Very difficult. I did a lot of
You
research,
didn't
but
do research, I think.
I didn't find. Only one case that is a different.
Mr. Barachaji will assist you. See, you see, show some authority for you to show that he's not entitled and to him to show that he's entitled. Just some authority.
My lord, one I have found, of course, I did not get
time to print it out.
No time to look for more, my lord. But however, this is an old
No,
judgment.
Mr. Qureshi is supposed to give. You give authority.
See, I did research, but I didn't find any such authority because
Here, my lord, it speaks about reversion. So, my lord, so it says that unless that person is a
superannuation.
unless, of course, I understand that point, my lord. But my lord will kindly see, we were not, at least at this point, we have not claimed, we have not demanded any
recovery.
Yes, my lord.
How can you do that after superannuation?
Upper superannuation.
They got some authority, Mr. Qureshi.
Authority, because the rule does not say about the promotions. It's silent in 1980-81.
So here, fairly, Mr. Bharti said that he said that there were no rules. There were no rules governing, and even then, the veterinary department has been adopting the district ministerial service rules. Correct.
That is 2017 only. But my case is of
Prior to that, draft rules were followed, my lord.
Draft
my
rules
lord,
I
even
don't know.
of course,
draft rules will not go by draft rules.
No, my lord. Even due respectful submission, my lord, is that there are a number of Supreme Court judgments today. I don't have it, my lord, where even draft rules can be followed, my lord. Once it is followed, it becomes a precedent, my lord.
But I didn't see the draft
There's
rule.
no draft at that point of time.
The draft rule is there, my lord.
At that time when he was given a promotion to driver.
Yes, my lord. Draft rules
attendant.
were in existence. This is.
They have never brought on record.
This is the draft notification, my lord.
Dated No date.
Is undated, my lord, but it is in the 90s, my lord.
90s.
He entered service which year?
My service was in 1981.
Then?
And promotion is given 82. 81. And immediately 85.
Case, no?
But the point is, my lord, promotion is against the rules, my lord.
No, rules is not there.
There's no rules.
No rules, no rules.
That is what, no? You said there's no rules. So, that is
My
why
lord,
it is a
only
privileged
thing is
case.
that, my lord, will kindly see the entry point, my lord. Because drivers, they have a separate entry point, my lord.
But that is there, but rules was not there.
Drivers, they have a separate entry point. Poultry attendant entry point is different, totally different.
Driver and poultry attendant are not same.
No, my lord. They're not same.
They're not grade 4.
No.
Driver is grade 3.
Grade 3?
Yes, my lord.
Poultry attendant is not grade 3?
4.
Grade 4, my lord.
He can't be promoted from grade 3 even notwithstanding the nomenclature of post from grade 4 to grade 3.
My lord,
Persons appointed in 1981,
the instruction which I received...
He was made a driver, he passed the test, he went for selection.
My lord, the instructions which I received from the department, my lord,
Then
they inform that poultry attendant retires as poultry attendant, my lord.
Mr. Qureshi, any other... I'll give you one day to obtain some authority. Then with
There
far
is
judgment.
only one judgment, but it's not applicable here. It says the possibility of such.
Then what's the point of citing it?
There is a possibility of such incumbents being sent back to the substantive post is not at all relevant in the matter of exercising a power of compulsory retirement if the officiating is not brought to an end by reverting the government servant to his substantive post before the power of compulsory retirement is exercised.
Again, speaks of reversion only.
Reversion. The government servant concerned must be taken to be in class. If they can be taken as a grade 3 only. Because I already retired. Only after retirement they have.
My lord, in this case, my lord, which is being cited, my lord, here the challenge is that because he is a direct recruit in a certain post, he could not have been reverted to a lower post. That is...
This judgment.
My lord.
Then what relevance will have in this case?
My lord, here, my lord, the only thing is that unless he is not a direct recruit in the driver post, neither in the senior gate driver post. My lord.
But he was appointed as chowkidar or poultry attendant first?
Poultry attendant. Yes, entered in the service as poultry attendant, my lord. So if he is reverted back to poultry attendant, there is nothing wrong with that. My lord.
No, how can he be reverted back after retirement?
That is exactly what he has challenged also.
This is a judgment says.
See, will that be just? If your person has been serving for 40 years as a senior grade driver, enjoying all the perks, benefits and pay and everything, now when he retires, you say that you retire the poultry attendant.
Only, my lord, he is definitely...
And there were no rules operating at that point of time.
Yes.
But only thing, my lord, he has enjoyed all the benefits, perks, remunerations, he has enjoyed, my lord. That he has enjoyed, my lord. That at this point, department has not made any demand that you please give us back.
If I acted in violation of any rules...
That apart, my lord. To regularize his pension, my lord. This is the stand of the department that he has to be reverted back.
What's the different scale between a poultry attendant and a driver?
Poultry attendant, this of course, my lord.
Yes, a post still exists.
Poultry attendant is still.
Exists as poultry attendant. There's such a post in the veterinary department. Poultry
Yes,
attendant
my lord.
now.
Poultry attendant is there. Several others, my lord. My lord, poultry attendant is there. That is at page 12, my lord, annexure 1 of the writ petition.
What is the...
Then hatchery attendant is there, my lord.
No, I'm not talking the order of appointment.
My lord.
I'm talking about the scale of pay now. Poultry attendant now and driver.
That, of course, I have not sought instructions, my lord, as far as the current pay of scale.
You look for judgment to take it up at 2 o'clock.
Let it come up next week, my lord.
I don't want to hold it any longer.
Completely.
But you're not coming authorities also. You say,
Authorities
no.
also, I tried to get.
Today.
Only one point I can
It's a
say.
very peculiar case.
Before the retirement, he could have been reverted back to this substantive post.
He was not reverted back. But he retired. He was given a notice of superannuation also.
Yes.
As senior grade driver.
Yes.
He retired as driver. Suddenly one fine day, went for his pension paper, said that no, you're a poultry attendant.
He's a poultry
That's the only
attendant.
thing.
That is the case only.
So get authorities. Post retirement when he can be reverted.
My lord,
reversal can be done before the retirement. Before the retirement.
My lord, as per the...
You don't do research, no? This is on you then.
My lord, this is the pay
take up
scale.
some judgment.
A certain pay scale is here, my lord. This is district and subordinate
Okay,
officers.
we'll have it on Wednesday. You bring authorities.
My lord, a difficulty, my lord. Wednesday, my lord, I have too many matters before single.
You don't have to argue. You just have to. She's there.
Authorities only.
My lord.
Get the pay scale and any authority which says permissible after superannuation.
Pay scale is also here, my lord.
What's the pay scale, poultry attendant?
My lord, here it only speaks of chokidar, cleaner, cook. Poultry attendant is not here. I'll. Huh?
Okay.
It is at par with peon, my lord. Chokidar, cleaner, cook, dark runner, handyman. It starts, basic starts from 6,500.
Okay, next.
Item number 6.
There's a judgment for direct recruit.
No, they're not
There's a
still
judgment.
disturbed by the fire, that's why. Mr. Areso, sorry to compel you to do this hearing, but only that because they say that this matter there's no purpose will be served to pursue this matter and view the elections have already been held.
Well, election has been held.
What remains in this writ petition?
But out here, the only grievance left or the issue left maybe Lordship need to decide is whether my lord, appointment letters for all the 4 headmen only mentioned 1 year. Now the system in the prevailing in the area is 5 years. So every
is that
1
a
year.
convention or is it a law?
My lord, in the statute it is silent.
Then
the act is silent.
So the convention.
My lord, and therefore
the convention then is it enforceable in law?
My lord, therefore only the limited aspect whether my lord there is discrimination is made it out to the petitioner or not. That is the only aspect. Election has been, Lordship has correctly pointed out. Election has been done. Somebody has been elected. He did not contest the election. My lord, since he has filed the petition. My lord. Only that aspect, my lord.
Suppose he succeeded petition, what will it be? Is enforcement of some convention, then you'll be put back in office.
My lord, if there is a discrimination, my lord.
You challenge the election.
If there is a discrimination, then.
You challenge the election then. The only thing we challenge election before the district council or whatever and say that the elections were, or before the chief, that you have a broken convention and whether convention can be enforceable, cannot be.
Well, may I suggest, may them come out Monday, I'll just take instructions.
Because
today is the
otherwise
Thursday.
there's no purpose.
Thursday, my lord, if he wants to challenge the election, my lord, let him do.
Lordship, even if he wants to challenge the
He
election,
can't, he's not a candidate.
He's not a candidate. Not a candidate. And that 1 month limitation also has lapsed.
That is true. Therefore, the limited issue involved here is whether if there is discrimination. Other remaining 3 headmen, they extend.
You can hear it now. There's nothing there, Mr.
My lord, the relief also which you have sought for is just renewal of the Sanat, my lord.
That is why, my lord.
It's an admitted fact that Sanat is for 1 year.
Others they renew. Same of me.
The case on
there is discrimination.
But the election, see, renewal of Sanat is consequent upon the post still being vacant, and you can still be renewed and you can occupy the office. Now that situation is not present anymore because there's fresh elections have been held, another person's occupying the post now. So that's the thing. What means here, Mr. Chariso?
Election has been held, but he challenged that minutes of the.
But what relief will you get? Even suppose
before elections.
Can you? You can't establish. You can't enforce the convention also. Only in England you can do it.
But there is a sheer discrimination.
Not in India.
And therefore,
India is only violation, not enforcement of convention.
It is in fact not convention, but that is the practices, customary practices going on in that area. My lord, kindly see page number 25. This is my lord, the rules they drafted and they follow. The entire locality, those villages.
Yes.
And my lord, the relevant para is Lordship may kindly come to page number 53. This is followed by the area, and the CMCP is to follow this. 53, my lord, point number 3. The term of headman and other executive members would be 5 years. If for any reason there is a dissension among the villagers against him, then a vote of no confidence will be carried out with a ratio of...
Where's the impugned order?
My lord, the impugned order may come to... my lord, that will be... First impugned order would be... Kindly come to page number 102. This is the first impugned order.
Yes.
Somebody has filed a complaint, and instead of hearing the complaint, my lord, the authority has passed this order. My lord, the Chief and Third Para of the Millennium CMCP hereby make a public announcement in such that Sri Paburading has been removed from the post of headman of the such after expiry of his sanat, dated such, and at the same time appointed Mr. V.K. Millennium. So the only ground is that 1 year is expired, not the complaint, not because of the complaint.
Issued to 1 year only.
Sanat is 1 year.
Yes.
Sanat is 1 year. And with regard to other, my lord,
then come the next page. Then you file for district council, correct?
My lord.
Then what was the order of the
then my
district
lord,
council?
page 104, lordship can see.
Yes.
Page 104.
It's application
My
for
lord,
renewal.
4 of them has been renewed. The same appointment 1 year. And only in my case, the last paragraph, with regard to Mr. Sri Bapora and the Dang, headman of Sanjat village, has temporarily remove him from the post of headman.
There's a complaint against you.
Because of the complaint.
Naturally.
Madam.
You should have taken part. Was there any did they bar you from contesting the elections?
Madam, there is nothing, but we were informed that he's not participated in the...
No, there was no bar. They didn't, I mean, the respondent number 3 or the respondent bar you from contesting elections again, correct?
He can participate.
Yeah.
He can participate.
Then why didn't he?
Correct. He can participate. But I'm not sure whether he really participated. But other affidavits say that he did not participate. Madam. Then this, we
And
filed
where's
a
the order of
political
district
appeal.
council?
Political appeal in 106, and the district council passed an order, page number 122.
122.
122.
Yes.
In this last paragraph, my lord, you can see, I have heard the parties now, such, 2007, does not fix the period of term of office of the Rangpashnong. Also, the Sanad issued the petitions for only for 1 year. It does not state that the Sanad is to be renewed on its expiry. The appointment order, such, is hereby set aside. However, the CM, in consultation with the CM of Right Mopo, is directed to appoint any monetary person to temporarily look after the said village till a full-fledged Rangpashnong is elected. Further, CM is directed to conduct a fresh election within Sansach. So this order was passed, we challenged, my lord, there was no stay order. There was no stay order. They proceeded for election. But according to me, my lord, that's election result would be outcome of the, would depend upon the outcome of this petition.
See, your removal was not renewal is because of some complaint against you. That's all.
My lord, renewal is not on the base, my lord, removal is not on the basis of the complaint. They said it because 1 year is expired already.
All the more words makes your case all like without me saying that there were complaints.
The orders
because yes, that order is very, that means for interference very difficult because as per the terms of your appointment which you accepted.
That is true. If my lord,
but you can't impute that, even like or infer that even the 1 year will amount to 5 years.
My lord, but that is true. Therefore,
you want a judgment in this case,
my lord.
You want to hear the matter,
my lord.
It's futile, but then it's just taking up judicial time. There's anything. But then we can hear you if you want. You have anything to say. But then the outcome is known. That's only this court can say that also.
My duty to apprise the grievance of the petitioner. If the impugned order is on the basis of the complaint,
that is not a complaint. 1 year is over. There's just a convention that that 5 years is given. It's not a rule.
And others, my lord, similarly for headman's day.
Therefore, doesn't matter. That's on a different. There are different. You're seeing the discrimination now. They should have been renewed. No elections were held. So you're impugning the order of the council only, and the order of the respondent number 3.
Yes, which
One of these orders has been set aside by the district council. Correct?
With regard to appointment of another third person was set aside. They did not reinstate me.
They don't extend your sanad.
They did not extend. The district council did not extend my sanad. They don't have their power to extend. It is the chief only. It is the chief only who is to renew and extend it.
So you're insisting the matter be heard?
My lord, even if Lordship has heard this, understood already.
No,
Lordship will pass a
hearing
perfect
means you
order.
said you're not ready. So
My lord,
that's why.
even
Because,
if I-
because since elections have been held, and even if you grant relief here, it's not going to put you back in that post. That is why. So whether we can entertain a futile writ, that's the only thing.
My lord, I'll take an instruction, my lord. Whether make up a
Yes,
case.
otherwise
otherwise,
we'll-
the
otherwise
Lordship
we'll
has
pass
understood
orders, yes.
the case already.
Just on Tuesday.
I'll just call him and take instruction. Yes. Much appreciated.
After hearing at some time Mr. H.L. Changareso, the council praised that we be permitted to seek instructions. Because it's futile. You can... Tough also since you didn't contest for elections, so... Yes.
36, daily list.
Where's Mr. Philemon Omri? I saw him here just now. Who's for the respondent? Lal Sanglu, yeah.
But this is non-payment of arrears, my lord, post-retirement. Other side, my lord, learned AAG Mr. Andy Shulai is appearing.
Where's Andy Shulai? He's on leave.
No, my lord, he is very much on the court today. In fact, my lord, why I
File
want...
affidavit.
Yes, my lord, the pleadings are
admitted
complete. Pleadings are complete, my lord. And the reason why I'm pressing for the matter is, my lord, because the person is hospitalized and he's on his deathbed. And the dues are pending for a long time, my lord, since 2011, the arrears. And he retired in 2016. What they state in the affidavit is delay and latches, my lord. Now, with respect to arrears and pensionary benefits, delay and latches do not apply, number one. Number two is, my lord, they say that the order issued by the DSCO granting the graduate pay, it relates to areas of graduate pay. That has been granted without the approval. Now, my lord, that they are saying it after 10 years, my lord. Order was issued in 2011. Order was duly marked to the director, my lord, school education. At page 11 of your lordships has, page 11 of my petition.
Yes, where's Mr. Shulai?
He's on legs, Your Lordship. This matter will take some time.
For the division bench.
Yes, Your Lordship. Your Lordship, if this matter can come up after a week.
Okay, we'll finish it off. Just be prepared after 1 week. Just due to the absence of Mr. Andy Shulai and AAG, this matter after 1 week. Yes.
Deeply.
Obliged, Your Lordship.
37.
Which matter is this that
chemist
name very familiar? Andrew Khonglam.
Promotion to the post of chemist.
He was not selected.
He was not considered by the TPC
Department
on the ground that one of his earlier regularizations, they found it not proper. So we have challenged that. We have challenged the DPC also, the constitution of the DPC also.
Who's appearing here? You are appearing?
Ma'am Yangi, Your Lordship, she's just coming.
Chemist.
this is actually earlier rounds of litigation was there, and as per those orders, earlier Annexion 9 is one of the earlier judgments, Milord.
No, I mean promotion it's not a matter of right. So you have to establish like there's been some.
Our whole case is that even consideration for promotion was denied to him.
But where's the order of this court earlier on? We
Yes,
come
it's
for
Annexion 9, page 57. If you come, Lordship comes to page 6, para 6, Milord, at page 60.
Yes.
Page 60, Milord. On the last date, that is on 31/3/2021, this court, on being apprised about this position, had directed the learned State Counsel for the respondent number 124 to obtain precise instructions as to whether the petitioner is being considered by the respondents for promotion to the vacant post of chemist, as has been indicated in the letter. Today, so-and-so learned government advocate to this query has referred to that part of the instructions received from the respondent number 124, wherein eligibility criteria for promotion and names of persons who are to be considered have been given. The note is taken cognizance by this court at this stage, and the eligibility criteria and names of persons as submitted is reproduced herein below. So he is there, his name is there.
Yes.
That was the submission on behalf of the respondents. A bare perusal of the eligibility criteria as set out is that promotion from amongst the assistant chemists will include persons who possess BSc chemistry and who have rendered not less than 5 years of continuous service in the post of assistant chemist. On examination of the table showing the names that are to be considered, it appears that from amongst the 3 persons who are serving as assistant chemist, presently the petitioner, who appears at serial 3, is the only one qualified for consideration of promotion, as he has the requisite prescribed qualification as also years of qualifying service. In consideration, this was a clear finding, my Lord, on the basis of the...
So that you are the lone horse in the race.
At that time. The whole point here is, my Lord, the government had considered and admitted
eligibility.
Eligibility, my Lord. In consideration thereof, and not to further prolong the matter, and keeping in view the instructions and materials received and produced by the learned GA, without further examining other issues, this writ petition is disposed of as follows. That with regard to promotion to the post of chemist, as the petitioner is qualified in all aspects for consideration thereof, the name is to be taken into account by the respondent number 124, and his name shall accordingly be considered as and when the Departmental Promotion Committee sits. It is also observed that though the respondents are relying upon the draft service rules, the same is yet to be finalized. It is hoped, therefore, that the same are finalized and notified at the earliest, so as to benefit the persons in service in the said department and put an end to avoidable litigation, such as has occasioned in the present case. Thereafter, my lord, the TPC was not held for some time, so we contempt petition was filed, and after the notice of contempt was issued, the departmental proceedings were.
So how many people are considered for promotion?
We, my lord, if your lordship comes to page 81,
yes.
These are the minutes of the DPC, my lord.
Yes.
My lord, page 81, my lord, from the second paragraph. After carefully scrutinizing all the papers and service records of the officers concerned, following are the observations of the committee members. My lord, number one, Sri M. Nongrum. Now, the committee noted that since he was an ad hoc appointee, the Director of Mineral Resources had no power and authority to regularize his appointment and then give promotion to him. As per the relevant Government Office memorandum issued by the Personnel and AR Department, only the Cabinet could approve for regularization of ad hoc appointments. Since his initial appointment is irregular, per se, his subsequent promotion also stands irregular.
Okay, fine. This one is gone.
So this is one is gone. Now, second, my lord, very interestingly,
yes.
my lord, he does not have the qualification. He was, my lord, R.D. Sangma was appointed as assistant chemist on officiating basis, joined the service on so-and-so date. He has the requisite qualification to the post. However, on the basis of cabinet approval, he has been recommended for regularization by the MPSC. Bidde letter dated so-and-so. And while regularizing his services, the Director of Mineral Resources was to be guided by the guidelines laid down by the government. Letter number so-and-so. The committee therefore requested Director of Mineral Resources to regularize the services of Sri Robert Sangma, Assistant Chemist, first, as per government instructions, and then come up with a proposal to the Departmental Promotion Committee for considering his case for promotion. Now, my lord, this how can a DPC request for regularization of someone's service? That is beyond the scope of the.
What was the consideration for the petitioner? What did he?
Petitioner Andrew Khongam was initially appointed as laboratory assistant on officiating basis on 10/1/2003 on the recommendation of the Departmental Selection Committee. So selection was there, my lord. He was selected through the Departmental Commission. Subsequently, he was allowed for regular promotion to the post of Assistant Chemist, Bidde, Office Order number so-and-so, dated 22/7/2008 on the basis of recommendation of Departmental Promotion Committee constituted by the Director of Mineral Resources for the purpose. The committee perused all the relevant papers and his service records and observed that since he was initially appointed on officiating basis, he should have been regularized by the Meghalaya Public Service Commission or District Selection Committee, as the case may be. As per the relevant Government Office memorandum issued by the Personnel and AR Department, only the Cabinet could approve for regularization of ad hoc appointments. Since his initial appointment
very peculiar situation then. He's regularized in the post of assistant chemist.
My lord.
Already regularized in the post as assistant chemist.
He was given a regular promotion, Your Lordship. He was given a regular promotion as assistant chemist.
My lord.
He was on officiating basis as a lab assistant. Then subsequently, he was allowed to officiate as assistant chemist. Then he was given regular promotion. I don't understand whether regular promotion and regularization is one and the same thing.
This is really strange.
And then, Your Lordship, when on examining the papers, the Departmental Promotion Committee has found that he was on officiating basis since he was appointed as a lab assistant. So, which is why they have
so
said...
no one is promoted?
No one is promoted.
Nobody has been promoted so far, but because the cabinet approval was not there for him, they have said that his there should be
cabinet approval. Since he says, they say the committee put relevant papers, service records, and observed that since he was initially appointed on official basis, he should have been regularized by the MPSC. That's correct, because he was appointed by the department or district selection committee, as the case may be.
Correct, sir.
As per relevant government office memorandum issued so only the cabinet could approve regularization of appointment. Since his initial appointment is regular, so his first appointment was which date? 2006.
2003,
so
Your Lordship.
No, this Konglam is 2006. Present
As in-
2003.
as in-
2003, I mean, he's
three has
eligible
a lab
for
assistant in
consideration as per the
2003.
cabinet memorandum, because the cutoff year 2007, correct?
I beg your pardon, sir?
Cutoff was 2007. for
2007.
realization, yes. He joined in 2003.
As a lab assistant, he joined in 2003, but he was
2003.
officiated as assistant chemist in 2006 and 7.
Very strange case. Now,
This
both
was
of
the
them-
only-
both of
this
them-
was the only
The only
problem.
two people who are considered are not fit because they've not been regularized.
And the third person who's...
No, the first person to forget, I mean, this Adi Sangma and the petitioner. Both of them are
These are the
contingent.
two contending candidates.
And the thing is that if he's found not eligible at that point of time, Adi Sangma, is he represented?
No, he's not.
He didn't make a
He's
party?
not even a party, Your Lordship.
Why?
But basically he has not been selected. So
No, even then, because any orders are passed, because the Department Selection Committee, you see, if he's not eligible, they cannot issue kind of directions that,
to regularize. How can that?
He's not eligible, not eligible.
Not eligible is not eligible. And DPC has gone beyond its...
But in his case, he has been approved by the cabinet, so which is why perhaps they
Not
have
approved, I mean,
requested. The second one, R.D. Sangma's name was approved by the cabinet. Here in this...
But that's correct, Mr. Chakravarti, that he was not regularized in his initial post.
Well, whatever, we have given all the
that
previous
is what all the departments
correspondences, everything we have given.
So which
now,
is...
my lord, we have also assailed this DPC, that it is not according to... It should have been headed by the Chief Secretary, in our understanding, my lord. They have...
No, but then it comes to the core issues that if none of the candidates who are on offer are qualified, so whether it's, whether that's a moot point to be gone into, it's not really, it'll have any impact on only with regard to the, legality of the directions or, the findings.
That, my lord. And secondly, my lord, that giving a proposal to the government, that the committee has gone beyond its...
that's correct. Yeah.
That is the evidence. Secondly, my lord, regarding his eligibility, it was considered before your lordships earlier that he is... So the department finds him eligible.
But but DPC has its own finding. But that is correct. You cannot say that it's a finding not based. If it's on an ordinary basis, court will surely strike it down. I mean, this you will surely ask the DPC to consent for promotion. But if it's on factual basis with regard to how is it regularized, how is the regular promotion? What do you have said in the affidavit?
I'll take your lordship through all the...
No, the affidavit, what have they said regarding his regularization in the post of assistant chemist?
They're saying that even that he was appointed as an assistant chemist under the Directorate of Mineral Resources Subordinate Staff Service Rules 2006. And the DPC that met at that point of time was not properly constituted, which is why that very promotion was not correct, inappropriate. That is what is our answer to that, Your Lordship. In para 6.
Initial appointment.
It is
was it a regular appointment? Was it his regularized?
That was on officiating basis. He was a lab. Yes.
On officiating basis.
Then he was allowed to officiate as assistant chemist initially.
Right. So what happened when So I'm getting confused.
Yes.
Let's see the thing again. Where's that?
DPC...
The petition also states the same.
Page 81. The DPC's findings.
Okay, Department Selection Committee, the 10/1/2003. Okay, then.
They say that
so it was extended again.
How a DPC which is sitting now can go into the correctness or wrong of an earlier DPC, Miller? When the department has sent the name
No, what about this page 22?
Of, Your Lordship,
22.
the writ petition.
Yes.
For regular promotion. He was first given in 2006 as on an officiating basis as assistant chemist. Then he was giving regular promotion to the post of assistant chemist. But he was not regularized, Your Lordship.
Is that regularized? How can he be promoted?
Then how? No, he was what is? I'm quite surprised that.
How can he be promoted?
And even our answer, Your Lordship, our answer in the affidavit is that this DPC which met for promoting him to the post of assistant chemist was also not correctly constituted.
So,
and they
so
have
you
relied
wipe out
upon
that and then you revert him back to what is
lab
his first
assistant.
post? Lab assistant.
No, I mean we are not on that, Your Lordship.
Well, something which has been done, can it be undone now, my lord?
But it has to be undone as per law also. That's
Well-
why we have to find they have
We have to correct the
lord,
situation.
15, 20
irregularity is writ large on the face of the record.
Yes.
But
If it is, but
because we see your earlier affidavits will have a role also to
Well, here
because
if
as per your statements which have been recorded in the judicial order that so there are persons who are eligible.
One
And
particular
even this
letter
person, Robert Sangma, is shown ad hoc officiating. How is he put in the eligible in the list? Why was he put in before DPC at all?
that's what.
Nothing.
Many questions come up, my lord. And in my
And as per the affidavit filed by the petitioner in the earlier round of litigation, Your Lordship, they have stated there were 4 posts of chemists in the department.
That's not an issue here.
That's not an issue. But, Your Lordship, 2 posts were already filled up by promotion by persons who were senior to him.
He didn't have an issue with that. He
No,
missed out.
then
missed
he
the
says
pass,
that
he
there is no provision for direct recruitment.
in this petition.
Yes, in that petition. He says there's no provision for direct recruitment, whereas the service rule says that 50%.
No, we're not on that point at all.
Yes. So,
We're
I
on
mean,
point
then
we on this. The point that we're on now is that when the
that the
petition
post
was
has already
closed-
been filled up by
No,
promotion,
no.
Your Lordship.
You're not even promoting anybody. So what are you talking about posts being filled
No,
up?
no, 4 posts were vacant in the earlier round of
2
litigation.
posts are still remaining.
2 posts are still remaining, and that is for direct recruitment, as per the service
Where's the
rules.
stand you've taken? Then why do you go to exercise over DPC then?
I'm also quite confused in this, Your Lordship. Because on the one hand, in the earlier round of litigation, it has been said that 2 posts have been filled up, and there are 2 more posts, and as per the service rules, 50% has to be filled up by promotion and 50% by direct recruitment. So they were aggrieved by that advertisement, calling for direct recruitment. Then again, now we find that they are saying that this is a list, I am one of the, within the zone of consideration.
The petition has a point. I mean, it's totally flawed, the DPC. It's totally flawed. It's on what basis? What are the findings?
The
What is
DPC has been constituted correctly, Your Lordship. One of my friend has been saying that the constitution of the DPC is also incorrect, is absolutely wrong, because as per the service rules, Your Lordship, the chairman of the DPC has to be the secretary, not the chief secretary, because this is a post, chemist falls under the...
No, we're not going to digress there. Just
Yes,
that.
no, because he had mentioned that, so I just wanted to clarify that our of the DPC is not correct.
Lord, I'm making my submission on that.
We're going round and round, Mr. Avarti.
Hello?
We're going round and round.
Yes.
Anyway.
Where is this?
Now the case been put up is that there were no vacant posts at all. So come to the matter, like notwithstanding anything else happened, since there were no vacant posts, everything should be washed out. The DPC also was totally unwarranted.
Then in the rejoinder also, Your Lordship.
Once again. See, the only stand is that issue essentially being non-regularization of service, irregular promotion given while serving temporary post, defunct Department of Promotion Committee giving regular promotion to non-regular incumbent who serves yet be regularized, then you know that, and the subsequent rejection, there's nothing arbitrary. That is your entire case. How do we straighten this out?
Then even in the rejoinder, Your Lordship, my friend is relying on some notifications that are meant for ministerial employees and not for technical employees.
Was that issue brought out in the first writ petition regarding his being not regularized and so on? So it was not ever brought out.
Never brought up. It was never brought up. It was conceded.
That's why the orders came out like that.
Well, orders were like that on the concessions made by the department. Now, my lord,
I'm not aware of that, Your
Now after
Lordship. but-
second writ petition, now they come up with other things.
And the first reason, my friend says she's not aware. The judgment itself is very clear.
No, I've seen the judgment, no doubt. But then there is a letter which was produced by the earlier council, 31/3/2021, Your Lordship. That is not, you've not annexed it also, neither have I got a copy of that.
On the basis of that, the judgment.
On the basis of which the judgment came to be.
What the letter?
Under what circumstances came to be passed, I'm not aware. This has not been annexed in the writ petition, and I don't have a copy also, Your Lordship.
No, this is just we have to find a way out. We can't just
There-
walk around circles
we,
like this.
we cannot go behind the judgment which has already been passed in a court. In a
No. Whatever it is, I mean, like their DPC, it's some interference is called for, but in what way? Because it has the course has to be corrected. It's just a question of setting aside, and then you end fumbling again in the dark, and you're coming with a petition again.
Sorry, Villain?
It's not a question of setting aside these orders again. You know, the situation remains the same.
Mother.
You'll have come back again another petition.
Mother.
There has to be some direction from
Closure
your part
also.
also. Closure means from your part. How are you going to, you know? Because then otherwise we'll what do you impute? It's unsustainable. The proceeding DPC.
In the first round of
Actually, they
litigation-
don't, with DPC, no interference called for, but then.
Because these draft rules which are being
applied.
My lord. But where my
Your rejoinder also talks about that.
Because you only challenge the DPC, that's all.
Yes.
DPC challenge.
That will go.
The constitution of the DPC. That is.
Not a constitution. Constitution is as per the rules, the draft rules.
As per the draft, it has gone correctly, Your Lordship, because
even then, but then even the recommendations
the
are.
recommendation.
Because if from the order itself, in the earlier round litigation, regarding the eligibility, you've given the list, and but then the manner in which the consideration was done is totally without any, without application of mine. In the sense that it was the regular post, was it regularized as a chemist, those kind of things. Whether you can recommend that the process be expedited so you can get promotion. So you're denying one end and then again saying that he also becomes a promotion in the end. So where does it stand? DPC should be clear. If it's before them, none of them eligible, over.
We have said that, Your Lordship, that he is not eligible at the moment. They have
So what
to
should
be
we do?
regularized first. That was the reason why they found him not eligible, because he was on an officiating basis. That's the only thing they have done, Your Lordship. They haven't gone beyond that.
But in the other recommendation, can it be sustained?
Which one, Your Lordship?
That tell him to expedite the regularization by the
That
cabinet,
request.
and then we will promote him.
No, I don't think that is what they are. That is their intention, Your Lordship.
It's
very clear and obvious.
apparent there that you're going to promote it, so you get the, and for same thing should do for him then. So the department itself will
They
move
have said
regulation
that,
with
Your
the
Lordship.
personal
He should
layer
be
department.
his name
Since
should be
already
sent to
served,
the cabinet for approval.
They'll send it. They should recommend and send it now for realization, and when it's time frame, we'll promote it.
That they will not
You should
say
have
so
done that.
much, Your Lordship.
DPC has gone beyond its.
Let me see if
Just get one judgment on interference with department proceedings.
I'll try
That's
to
all.
get that. I'll also
Then we'll
get
close it. Yes. We'll have to after
and then
1
I'll
week.
find out that letter also.
Yes,
that
one
what-
letter. One we will dispose it of.
Well, after the 15th.
15 of March.
I'm going on.
Otherwise, it's substantially hurt. Yes.
After the.
But one thing sad, Mr. George, is that even if you succeed in this petition, you come back to square one. That's the only thing.
This is the third round. This is the third round.
The only thing is that when there seem to be some
inimical interests.
that should not be there.
Yes.
Anyway.
What happens? Person fight for his rights is always.
Always feels that there is some
it's
other
always
interest.
targeted or something.
Yeah.
Second point.
My lord, we are dealing with the mining department.
Yes. The court is
That
well
itself
aware of.
that speaks a lot.
Yes. Dr. Mojika. Yes, we all dispose of these matters. These batch of matters. What's the point of holding them? Some 18, 19, 20, all these petitioners, they say, please dispose of a direction that you examine the report and do whatever is necessary. Mr. Paske also, he has said that dispose it off and what to do?
Dispose with the direction, madam, to
Your report is still sitting on the report now for how many months?
Madam.
Waiting for it to hatch. The findings to hatch, rather. What do you propose?
Because I do not know what is there in the report also, madam.
We can't keep on joining them, but they're also impatient. Mr. Sheikh said with 10% they've got. He's eagerly waiting for 90%.
It's not disputed, Lordship. Only the thing who is going to pay. Now, the Ministry of Home saying that it is the duty of the NBC, NBCC saying that it is the duty of the Ministry of Home. So, apart from that, the remaining 90% Uber has to pay. Now, it's not that 2006.
You haven't got instructions, latest instructions.
I wrote to them, my lord. They're only saying that they're examining. BSF IG has submitted the report. They're examining. But some direction is given to them, my lord.
And close the matters.
No, my lord. To place the report before the court.
Place the report before the court.
Yes.
Where's the report? It's closed. It's Mr. Paske. The report's confidential.
Yes. The report is confident. We also have not received a copy of the report.
You're not privy to that.
We are not privy to that.
He's NBCC, my lord.
Now, in the counter affidavit, the Ministry of Home saying that, in fact, we are not supposed to make party. Now, the NBCC is saying that, no, it is the duty of the Ministry of
No,
Home.
that is not going to this aspect because they also know they are the financial, we are the implementing agency and they will finance the project, the MHA. So they are the funding agency here.
Some direction is given to the Ministry of Home, at least they can produce the report within a short time.
Please, Lordship. I also agree to the proposal made by the senior advocate that can be some direction can be given to submit the report without disposing the matter.
Who's to give the final seal on the report? BSF has prepared the report, correct? And sent to the ministry. Is that correct, Dr. Mojika?
But the letter is
It
here.
was joint survey.
Please, this letter.
Joint survey by BSF, NBCC.
Yes.
And the report has to be given by MHA.
That is what? This is which year? 23. See, comments have been sought from your government also.
So the survey was already conducted, to the best of our knowledge. These batch of writ petitions have been placed together because they relate to the Indo-Bangladesh border fencing. As far as one of the cases that I am appearing in, the dispute was with regard to the payment of compensation and who shall pay it. The nature of the dispute raised by the petitioner was that there were 2 rounds of acquisition. In the first round of acquisition, a line was drawn with regard to the border fencing. After a few years, they started a realignment process. In that realignment, about 26 additional villages were affected. So now the state government placed a request for additional funds in respect of these additional villages that were affected. So the dispute started from that. So this caused them to lead a survey, to conduct a survey.
So after the survey is done, that means there will be a total reanalysis of the amount of compensation to be paid as per the rate.
Additional amount which is to be paid for these other affected.
These people only additional amounts. All the people here.
No, the one with Mr. P. Sangh was appearing.
And Mr. Sheikh.
One that's from Southwest Province. He is representing 6 that I think, and I am representing 1.
Southwest Garo Hills.
Southwest Garo Hills.
So this inquiry, Mr. Pathki, is done with regard to the entire stretch,
Yes.
Southwest,
Yes.
South Garo,
Yes.
everywhere.
Yes.
Entire stretch.
Not actually what happened, my lord. In 1990s, my lord, there was an idea came up for IBBF, border fencing, my lord, and the contract was given to NBCC. No, at that point of time it was given to another agency.
Border roads.
BRO, and a lump sum contract was given to them that they will be liable to pay the land compensation also. And that time they acquired a stretch of land, so having certain width, my lord. Maybe that's not mentioned, but 5 meters or 7 meters, whatever width, my lord, and the entire stretch. Now, government was under the impression that for that acquisition, that stretch of land, the compensation has already been paid by border roads, my lord. Now, recently, my lord, idea came up for fencing it. Earlier, it was border pillars only. So, for fencing, the realignment was required, my lord, and for that purpose, they had to acquire some additional land in some portions of land, my lord. Now, the question came up. It appears that even earlier round, in 1990s, when the land was acquired, the compensation has not been paid.
Never paid.
It appears, my lord.
Then we are heading into we have to consider tribunal.
And to find out the records of after 30, 40 years was there.
Tribunal means to be chaired by the deputy commissioner or something to go into all this. Otherwise, based on the records available, nothing will happen then. Because if it's been 2 stages, if we say was correct, from boundary pillars to border fencing.
Border fencing. So now the report is with the government, my lord. What BSF IG who conducted the survey, my lord, or inquiry?
So what
he has not conducted survey as a BSF person, my lord. He was deputed by the government of India to conduct the survey because being a local officer.
Now what should we do then? What alternate remedy can they seek?
The only thing, at least the report can be placed. What is there in the report, my lord? Thereafter, maybe a future course of action can be decided.
Report of the court. What will the court decide in the report? Go through it and decide on disputed facts.
That is the question.
Court cannot go into it. Even if the report is pleased, we can't pass orders on the basis of the report. If only the report is acceptable to all, then Otherwise, court will not issue a manifest or something.
They may dispute the report also.
Of course, they'll dispute the report. Right, Mr. Sama? That's why it has to go before a certain...
Here there were internal communication between the state authorities as well as the Ministry of Home.
Yeah, even this one,
they could have...
They said that this report from the Ministry of Home Affairs says that comments on inquiry report have also been sought from Government of Meghalaya.
My lord, true, my lord. My lord, the only thing is that, lord.
No, whether the government has given any comments or not, that or NBCC, I think they have to give comments also on that.
Not from NBCC, only from state.
I believe this is already pending with the ministry in the center.
No, you only send your comments also.
We don't have that instruction. Because what we understand is the exercise here was already complete, then the entire matter was sent to the center.
for payment.
Take down. We'll reproduce this letter in the order. Yes. These batch of matters with respect to the payment of compensation for stretches of areas in southwest, in South Garo Hills and
South Garo Hills and
southwest.
West Garo Hills.
South and southwest.
South and southwest Garo Hills have been pending before this court for a considerable period of time. Stop. The last development was that the Border Security Force, comprising members from the Border Road Organization, Revenue Department, Government of Meghalaya, and National Building Construction Company, sorry. No. That the Border Security Force, held an inquiry comprising members from the Border Road Organization, Revenue Department, Government of Meghalaya, and National Building Construction Company to go into the various issues which were set out in these series of writ petitions. Next platform of communication dated 21st September 23, which has been produced by Dr. Nitish Mozika. It appears that the inquiry report has been submitted to the Ministry of Home Affairs, and the same was under examination, and that comments had already been sought from the Government of Meghalaya. Stop. Next paragraph. From this development, the parties before this court not aware as to what has transpired thereafter. Stop. In this view of the matter, what should we do? In order not to prolong the matter any further, it is directed that the report as furnished be placed before this court.
Or you can file an affidavit, my lord, before the next date.
Or yes, is directed from.
What is the outcome of the constitution?
Yeah, ma'am. It's directed that you're which respondent with Home Affairs. No, just a respondent. You're just union.
5-6.
5-6.
Or Union of India, maybe different.
Yeah.
Home Ministry.
The Ministry of Home, the Union of India with Home Affairs.
Department of Border Management.
Department of
Border Management.
Border Management. File an affidavit within 3 weeks with regard to the exact status, as also to the report. Stop. This order has been made to enable early closure of the matters which have before this court. This after
4 weeks.
4 weeks. Just do that. Otherwise, it just linger again and again. I would say.
Please.